si G. Tanji. Welcome to Kababyan today. If you're just joining us, we are taking your calls live here in Los Angeles. Kasama po natin ang mga attorney, immigration specialists, of course, Attorney Allison Aquino Silva and Attorney Richard Lowe. Kasama naman natin sa telepono right now si Johnny from Long Beach. Johnny?
Hey, good afternoon, G.
Hey, good afternoon to you too. What is your question for our attorneys this afternoon?
Yeah. Hey, you know what? First, just to let you know, you're getting prettier and prettier.
Oh, uy, salamat! Alright, ano po yung tanong ninyo tungkol sa immigration?
May tanong na ako kasi kung pumunta ka dito sa States
Yes.
as fiance visa,
Okay.
and then you change your mind not to get married sa petitioner mo sa nagano, and then can you stay in U.S. And then married to like a citizen person in the United States, not going back to the Philippines?
Okay, so the question is...
Could it be possible?
Yeah, is it possible he came here on a fiancé visa, they both changed their mind, however, he met someone else who is a U.S. citizen, can he stay here and get married to that other person as opposed to going back to the Philippines? Richard?
Yeah, you know, fiancés are treated slightly differently than other immigrant visas, and one of the prohibitions of a K-1, as what you come in on as a fiancé, is that you cannot sort of change ships. You have to dance with the woman who brung you. Let's say you can't change and have a different wife, or different husband. If the person who petitioned you as a K-1 has to be the person through which you adjust your status. You are prohibited from adjusting through anyone else. So there are ways to continue on with that petition, even if you are not continuing on with the relationship, but you cannot go to have another person petition you. In order to do that, you have to return back to the Philippines and come back in.
Oh, but I don't think Johnny wants to go back to the Philippines. He wants to stay in America. Obviously, you need some advice, Johnny. Please, call Attorney Allison Aquino Silva and Attorney Richard Lowe. Kasama naman natin on the phone from Carson si Iza. Iza, ano pong tanong ninyo?
Magandang hapon po.
Magandang hapon din po. Ano po yung tanong ninyo po?
Send po ako. At saka, na-file ko na yung 245I noong 2001 sa anak ko.
Okay.
Kailan bang priority date ngayon ng 245I?
Okay, first of all, for the people that don't know, what is a 245I?
And actually, that is my question back, because there is no such thing as a 245I application. There are applications that cover you under a law called 245I. So what he filed was a family-based petition. Like he mentioned, he petitioned his child. So
2001.
He filed in 2001. And so his petition for his child grandfathered him under this law. And what that means is that since his child is covered under 245I, eventually, when they get to his child's place on the waiting list, the child can just go ahead and move forward with the adjustment application and apply for that green card. So with regards to how much longer, if he's a U.S. citizen, the current priority date for filing under the new visa bulletin schedule is 2005, so that child should be eligible right away. If you're a green card holder and your child is unmarried, again, it's at 2005, which is current, and they can move forward right away. If he's a U.S. citizen and the child is married here in the U.S., the current priority date on that is only 1995.
Okay,
and so it might be about another 6-year wait.
All right, and I suggest you go to their website to find out about the priority dates. You can check that out. Okay, kasama naman natin si Oscar. Oscar from Downey. Oscar, ano pong tanong ninyo?
Yeah, I'm calling regarding dual citizen. I called the U.S. Immigration, and they told me there's no such thing as dual citizen for Filipino and U.S. citizen.
Okay, well, Oscar, you should have called the Philippine Embassy, not the U.S. government. Am I correct in this?
Well, you know, the citizenship is a little bit tricky. You're not going to the governments aren't going to say they allow dual citizenship. And in fact, the United States does allow dual citizenship only with Ireland, I believe. So everything else, they sort of just allow you to retain your other citizenship, but they don't call it dual citizenship. So when a person from the Philippines becomes a U.S. citizen, the U.S. does not ask them to renounce their Philippine citizenship, so they can continue to hold both passports. But the U.S. doesn't recognize them as being dual citizens. So it's a little bit tricky to, it's a little semantic to say, is it dual citizenship or not? Basically, you can hold two passports, Philippine and the U.S., and it's not a problem for either country at this point. I think some people are reluctant to get a U.S. passport now because the Philippines are starting to tax U.S. citizens when they go back. So that's some issues there.
They want the money any way they can get it.
Any way you can get it, yes.
And also in regards to his question, so like Richard was indicating, the U.S. doesn't encourage dual citizenship. And so when actually, and as far as the Philippine government is concerned, when a Philippine citizen becomes a naturalized U.S. citizen, you actually do lose your Filipino citizenship.
I see. Okay, we have to go to break as of now, but magbabalik po kami here on Kababyan Today to take your calls. Join us once again. We'll be right back.